Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson, Jr. presiding. The court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mr. Hendra,
Good morning, Your Honor.
you're early today. Your matter's not till 11 o'clock.
Oh, well, thank you for letting me know. I had it on the calendar for 10.
No, we got you at 11.
All right, thank you, Your Honor.
We'll see you then. You want me to put you in the waiting room or remove you?
I'll just hop out.
Okay, just hop out then. Good
Yeah,
enough.
then, thank you.
Mhm. Mr. Sefton?
Good morning, Your Honor, and how are you today, sir? Hello, am I on speaker? Let me just make sure I'm speaking. Can you hear me, Your Honor? Why am I not hearing anything? Up all the way. Hello? Well, I'm here. I'm not sure what's going on, but I'm here. All right, let's see. What am I doing wrong here? All right, I guess I'm in the waiting room.
We're back, we
You
think.
just gotta turn off oh, your microphone. Okay, it's open already. Yes, minimize. Hello?
Mr. Seaton, can you hear me?
Mr. Good morning.
Yeah, thanks, Israel.
Sorry about that. Yeah.
Okay, we had a technical difficulty here.
Only a little? That's amazing. Most of the time I have more technical difficulty than I can handle.
What brings you here today?
Midland Management versus Kalia Coleman. The case number being ending in 219.
You got a motion for summary disposition?
That is correct, Your Honor.
Yeah, I have Ms. Coleman. Let's see if we can't get started. Hello?
Hello.
All right, let's get started. This is file 2197219, Midland Credit Management versus Kelly Coleman. Excuse me. Date and time for motion for summary disposition. Appearances.
Michael W. Sefton, P 31320, appearing on behalf of the plaintiff's counsel. I think it's Stephanie Pettyway in this particular one.
And what is your name, ma'am?
Kelly Coleman.
Ms. Coleman, did you file an answer to the motion for summary disposition?
Yes, I sent a response back as well as I sent another letter out for a validation of the contract.
When did you send that answer? I don't see any answer here from you. I don't see any pleadings from you after this motion was counted. On May 15th, there's no indication you filed anything else. When did you file it?
I'm looking at my calendar, Your Honor. After we got back on the call and you asked me, was I going to respond? And I had said, yes, I sent it out on the May 25th.
I don't have it here. Counsel, have you received it?
No, Your Honor, I haven't received anything on that.
Well, I'm gonna have to adjourn this for a couple of weeks. She said she filed a response. I can't proceed at this point. All right, today is what day? Today is June 12th.
Yes,
May I ask how she filed that, Your Honor? Was it by electronic or was it by mail?
How did you file that, ma'am?
mail.
Okay. All right, I'm gonna adjourn this matter to June 26th. I will not adjourn it again. June 26th, 2023 at 10 a.m. Motion for summary disposition. Did you send a copy to the other side?
You said to the other side. I responded to,
You have to send a copy to your opposing counsel. Did you send a copy of that response?
yes.
All right, we'll see. All right.
I cannot verify the address that should it be sent to?
Same address on the complaint, ma'am.
The PO box in Warren, Michigan, correct?
Yes, ma'am.
Okay.
612. All right. I can't proceed then, but there'll be no further adjournments. Thank you both for coming in. We'll see you on June 26th, at 10 o'clock.
Thank
Okay,
you. Your Honor. Appreciate your consideration. Have a blessed day, Your Honor.
Thank you. What do you want to say, ma'am?
No, thank you, sir.
All right, we are on the record.
Can't hear you.
We are on the record calling file 23-145-359. LVNV funding versus Erica Steps. This appears to be our second pretrial. Your appearance.
Judge, may I please court Richard Grusin for the plaintiff. I am the attorney of record. My bar number 35222.
And your name, ma'am?
Erica Steps.
Okay, we were last together on this file on May the 15th. At that time, the court opened your written discovery. Where are we on that?
Judge, I can tell you from the plaintiff's perspective, I sent to defendant at her residence, noted on her answer to complaint, written discovery consisting of requests for admissions, interrogatories, and a production of document requests. I served them out on May 25. Defendant is still within the time to answer that written discovery. So I would ask at this time, if the case can't be settled today, that we have continued discovery so that we can see where we end up with defendant's answers to my discovery. On that, I rest.
And what about you, Ms. Steps? Are you planning on written discovery?
I am still waiting on the contract from them. In their complaint, they mentioned contract, but I still do not have a contract. That if I'm breaching the contract, don't I need the contract? They said it is in my possession, but it is not.
All right. We'll continue your written discovery. Your next day with me will be July 10 at 10 o'clock.
July 10th.
Is there anything else we can accomplish today?
Plan for us, Judge.
Anything for you, ma'am?
Nope.
All right.
Just waiting for the contract.
Thank you both for coming in.
Thank you.
Be safe.
You too.
Good morning, gentlemen.
Good morning.
I don't have Mr. Haney.
Hmm.
We're one guy short. As soon as he gets here, we can get started.
All right.
Put you guys back in the waiting room.
Thank you.
All right, gentlemen. We are on the record calling file 22-192-503. Auto Owners Insurance Company versus Rescue Unit Towing, Drake's Collision. Could I have your appearances?
Good morning, Your Honor. Jared Anjeski, P77599 on behalf of the plaintiff.
Thank you, Your Honor. Kurt Thornblade, P25858, on behalf of one of the defendants, Rescue Unit Towing, Inc.
Okay, gentlemen. We don't have Mr. Haney here for some reason. We had scheduled today a motion for summary disposition, but it appears that we have an unresolved discovery fight that needs to be resolved before we get to that. What's going on here, gentlemen? At least what I'm reading from counsel's argument is that you guys had an informal understanding to get discovery done. And then when you weren't able to settle the case, you decided you weren't going to do any more discoveries. That what's going on here?
No, Your Honor. This motion was filed in January. No, it was filed in February. And at that time, discovery was still ongoing. And when I had written up the motion at the direction of my, I had requested to suspend discovery pending this motion. Well, that part of my motion is mute, and a discovery has been completed. I have provided everything that has been requested by Mr. Andrzejewski, and that's been stated on the record. So the motion for summary disposition is based on the fact that the complaint is based upon 11 separate counts. So we're asking the court to look at those and determine if the court feels that this matter should go to trial at all, or if so, are there any counts that can be eliminated at this time in order to facilitate a final disposition?
Mr. Andrzejewski?
I agree with Mr. Thornblade's comments.
Okay, who is David Avery?
David Avery is the owner of the named defendant, Rescue Unit Towing, Inc. He's the president of the company.
And why is his deposition necessary?
Well, that was mute because Your Honor already ruled that in view of the small amount of damages involved, no deposition should be taken.
Mr. Andrzejewski?
That's correct, Your Honor. I had requested to take his deposition in order to ask him about the affidavit, but you had already ruled that since it's a small amount, written discovery only, so we abided by that.
Don't tell me numbers. I'm not interested in that. But at one time, you guys were on the verge of settlement, and then things blew up. What's going on here?
I believe there was an offer on the table, but then that was rescinded. We do have a couple other cases. I believe that had a factor into this. I can't speak to what rescue unit, and I can't be in their mind or of Mr. Thornblade either. So I'm not sure specifically why that offer was rescinded.
Yeah, what's happening in this case? I have nothing to do with these other matters.
Yeah, as far as I know, there was an offer, and offer was rescinded by defendant. So there's no offer on the table.
That is correct, Your Honor. My client does not want to this case at this point, at least not until there's a ruling on this motion. It might be a good case to go to case evaluation. And perhaps my client would feel differently at that point, but I can't settle for my client. He's the one that has to authorize it.
Okay, well, here's what I'm going to do. I'm going to give you guys an adjourned date for this motion. It's going to be July the 10th. Somebody give Mr. Haney a call. I know he filed a concurrence, but I don't know whether he wants to appear or not. And then July 10th at 10 o'clock, we'll have to go forward with the motion.
But Your Honor also has it scheduled for a pretrial, so I assume we'll adjourn the pretrial as well.
The pretrial will be adjourned to that date as well.
Thank you, Your Honor.
Now, again, you guys have other matters to fry, and that's fine and dandy. But I only have one of these cases. And I don't want my case to be caught up in whatever may be going on in your other cases. Because the other matters are separate and distinct cases. Okay? So let's function as though they are separate and distinct cases. That's why they have different case numbers. That's why they have different judges. And I even would assume they're in different courts.
That's correct.
July 10th, gentlemen, 10 o'clock.
Thank you, Your Honor.
All right, thank you, Your Honor.
English composer Rebecca Dale writes a lot of music for BBC television, major film composer as well, but also concert composer. Like that piece called When Music Sounds, a choral symphony. Kansas Ensemble showcased Rebecca Dale's music as we supported WBC General. But at least for those music was nice. Like in many cases with the music of Maurice Ravel, it started off as piano music that was supersized by the master orchestrator. Maurice Ravel himself, the orchestral version of his wonderful use in the Speak Out radio system.
Hello? What is your name, sir?
Good morning.
Good morning.
Good morning, Your
Desmond Holmes.
All right, on the phone, 616, who are you?
Your Honor, it's Attorney Jeremy Chisholm for Reliable Auto Finance with Mr. Holmes this morning.
Let's call your file then, get started. This is file number 2219813, Reliable Auto Finance versus Desmond Holmes. Date and time for plaintiff's motion to reopen the case. Appearances, please.
Good morning, Your Honor. Jeremy Chisholm, P74670. I'm the attorney of record for the plaintiff.
And your name again, sir?
Desmond Holmes.
Mr. Holmes, did you file a answer to this motion, a written answer to this motion to reinstate the case?
Yes.
When did you file it, sir?
No, I ain't filing. My bad. I didn't do it.
All right,
I'm sorry about that.
let's start with Mr. Holmes. We'll start with Mr. Chisholm's motion. Let's hear from him.
Judge, as we detailed in our motion, we timely served this complaint. No response to the complaint was filed. We did file, I believe on two separate occasions, attempted to file a default judgment after the 21 days had passed. I know we did send in the proof of service as well. Apparently those weren't received, or they weren't entered, or we're not sure what happened. And the case was dismissed for lack of progress. So given the fact that the defendant was served personally, within the time of the summons, and that no response was filed or anything, and we'd ask that the case be reinstated. I don't see any prejudice here for the defendant, and certainly, I guess it gives him certainly the opportunity now to answer the case and proceed if he needs to.
Mr. Holmes, you did not file an answer. Is there anything you wanted to say in response to this motion?
No, I've just got to pay, sir.
Okay, well, let's do this then. What I'm going to do is I'm going to grant the motion to reinstate the case. I'm going to give you guys a pretrial date. Your pretrial date with me is going to be July 10 at 11 o'clock. What I'm going to do now is I'm going to put you guys into a chat room so you can talk about resolution on the case. If you're able to resolve the case, come back to me. If not, I will see you for a pretrial on Zoom, July 10 at 11 o'clock. Okay?
Okay.
All right, let me get you to see if I can make the technology work today. Get you into a chat room.
Thank you, Your Honor.
Just hit join, Mr. Holmes, when it comes up on your phone. There you go. We are waiting for Ms. Moore to connect to audio. All right, we're here now. We are on the record calling file number 22-192547, Forest Health Medical Center versus Shante Moore. This is the adjourn date for a motion for summary disposition filed on behalf of the plaintiff.
Good morning, Your Honor.
Hold on for just a second. Hold on for just a second. She seems to have gone off for a minute.
Tap to speak.
Okay, she's back now. Let's have your appearance.
Good morning, Your Honor. Stuart Collis, P49530 on behalf of plaintiff.
And what is your name, ma'am? What is
Shante
your
Moore.
name? All right. This is the adjourn date for Mr. Collis's motion for summary disposition. I adjourned the matter the last time we were together because the defendant said she had filed an answer and that had not yet hit the court file. That has hit the court file. The court has had an opportunity to review both the motion and the response to the motion filed on behalf of the defendant. Mr. Collis, your motion.
Your Honor, this is time date set for a motion for summary disposition. We've attached numerous documentation showing that Ms. Moore was at Forest Health. Ms. Moore availed herself of the services. And in addition to that, it signed paperwork saying essentially that she would be responsible if the insurance company did not pay. Quite frankly, under Michigan law, it's just a repeat of Michigan law, because under Michigan law, the person who obtains the services is the responsible party, not some third party who we have no contract with. Therefore, Your Honor, and in light of Ms. Moore's answer, which literally has no contrary evidence, we would ask that the motion for summary disposition be granted, that the amount of damages in this case is $22,400, court costs $237.96. Statutory attorney fee is $75 for a total of $22,712.96.
Ms. Moore.
Yes.
Your response, ma'am.
Oh, my response was, I told them at the beginning of this, 2 years, almost 3 years ago, that they were billing it improperly after they sent me a bill probably 6 or 7 months down the line. We've been going back and forth with Blue Cross, and then I never heard back from anybody until I got this lawsuit. And then when I called Blue Cross, they said they never reached back out to them after they filed the last, they gave me a date too. That was back on the 21st, April of 2021, when I had to call back up there and I asked them to resubmit it back to Blue Cross because this was a medical need. And they knew it was a medical need by my doctor outside. And since there, I've been sick and they didn't even offer any help. And I'm still struggling to this day and got to get another surgery due to the surgery that they gave.
Anything else you want to tell the court?
The billing was done improperly. If I still owe the bill and this was a medical need, and Blue Cross pays for bariatric surgery 100%.
Ma'am, did you read the plaintiff's motion and the attachments there from Blue Cross?
Yes, and those are the ones they got prior to, because they should have got the same ones that I got when Blue Cross, I sent it back. Blue Cross said they never received it again because you get an 18-month period. We were going back and forth, probably 6 months to almost a year. When I first got the bill, they stated that I owed 19 at one time. Then it was 22.
All right, Mr. Collins, your response.
Your Honor, like I said, she signed the contract that said she's responsible regardless of whether insurance or not pays. Whatever she needs to do with the insurance company is her responsibility. And quite frankly, we probably have gone above and beyond in not only billing the insurance company, but as you indicated, getting all the documentation for her and doing what we needed to do. So if she has a dispute with her insurance company, she could certainly file a third-party complaint. She was on notice by Blue Cross and Blue Shield of Illinois, apparently, that there were, that she wasn't covered, and she still did nothing. So again, I don't see how she's not liable in this case, and her copays, et cetera, totaled what they did. And we'd ask for that judgment today.
All right, the court's prepared to rule in this matter. I'm going to rule under MCR 2.116 C10. The defendant, in her answer, states, and I'm at page 2, in February 2020, defendant underwent bariatric surgery at the recommendation of our physician. So there's no question that the surgery, the medical services, were in fact rendered to the defendant. The question is the payment. The information provided in support of the motion by the plaintiff indicates that for whatever reason, Blue Cross Blue Shield of Illinois disagrees that this was a covered service. But in addition to the information that the plaintiff provided concerning Blue Cross and Blue Shield, plaintiff also provided documents signed by the defendant, one of which was entitled Guarantee of Payment. And the next one that is relevant is another one described as benefits understanding. Looking at, which is plaintiff exhibit number D apparently, I understand that the benefits that are discussed with me are not a guarantee of payment by my insurer, but a description of my benefits interpreted by my insurance company. Then it goes on to say that the defendant is going to be responsible for any non-covered items. I also understand that I am responsible for balances not paid by my insurance carrier, such as deductibles, co-insurances, co-payments, and any non-covered item, including any reasonable and customary determination. At the previous exhibit, which is described guarantee of payment, the document describes itself, and again signed by the defendant, in consideration of providing the services described in the patient financial agreement into between the patient and the provider, and any financial accommodation that has been or in the future is extended to you or the patient by the provider, you intending to be legally bound, absolutely, unconditionally, and irrevocably guarantee the prompt payment of all charges when due and at all times in the future for which you're responsible. There may or may not be a third-party payment, but that in Michigan does not mean that the provider of the services is not able to claim against the person who received the services. Now, the patient may or may not have a cause of action over against Blue Cross Blue Shield, but that is not a defense against the claim brought against the plaintiff. I note that no affidavits are submitted here in the support of the arguments raised by the defendant. The court finds that there is no genuine issue material fact. The plaintiff's motion for summary disposition is granted under MCR 2.116 C10. Court finding there to be no genuine issue of material fact. Mr. Collis, I look forward to your proposed judgment under the 7-day rule.
Thank you, Your Honor. I'll have that sent out today.
Ms. Moore, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of the day that order judgment is entered. Thank you both for coming in. We are off the record.
Thank you, Your Honor.